Justice Perez.
Just to make sure that I heard everything right in the past discussions, what is made criminal or is made punishable under the law is for a healthcare service provider intentionally providing incorrect information. When you say incorrect information, that is defined by what is correct information. And from the discussions we have had thus far, the determination of what is correct information has been delegated by the law to the FDA. In other words, at this point, we do not know yet what will be criminally punishable and what is not criminally possible, because the law itself does not define or confine or delineate what is correct information. It is yet forthcoming from the FDA, and if I heard you correctly a while ago, that cannot be really a determined fact at any point of time, because it will change as the FDA analyzes or is confronted with drugs that is presented to it for evaluation or for analysis. My point is that this law makes criminal what is an act which is yet undefined. Is there not something wrong with the law?
No, Your Honor. The law defines punishable acts which could be considered culpable at present.
And
because the FDA has already certified certain contraceptives as medically safe, legal, and effective. The Solicitor General last time, Your Honor, made a presentation of I think more than 50 contraceptives which were approved by the FDA. If a doctor would say knowingly a contrary view that these contraceptives are not safe, they are illegal, they are abortifacient, then he is amenable for prosecution under the law.
So, yes, it is the FDA which determines or which defines the crime.
No, Your Honor. The law defines the crime, and the FDA is the one which determines whether contraceptives are medically safe, legal, non-abortifacient.
The correctness or incorrectness of information depends upon what the FDA says is safe, legal, etc. And we have to accept that at this point, this law has not listed what the FDA has determined to be safe, legal, etc. In other words, at this point, the law is yet incomplete.
Now, Your Honor, the law is complete because the FDA has been in existence, contraceptives have been in existence, and the FDA has already certified that certain contraceptives are medically safe.
And that is not appended into the law, that listing of that safe contraceptives. And it can be, that list can be prolonged, or more can be added to the list. That list can be, items in that list can be deducted. Items in that list can be erased in accordance with the determination of the FDA at one particular time.
Precisely, Your Honor.
In other words, what is correct or incorrect will vary and will be determined by the FDA, not by the law, because the law says, FDA, you determine what is correct or incorrect. And you say that is already a complete and a correct delegation. Will you please discuss that? Why that is permissible under our system of laws?
Your Honor, the reproductive health law already made the standards under which the FDA will have to be guided. And because the FDA is the competent administrative agency which could determine whether these contraceptives are medically safe, effective, legal, and non-abortifacient in relation to Section 4A. So there's nothing wrong with the law. It is complete.
It is complete because the Congress, through this law, has already delegated to the FDA the function of defining what is criminal under this law.
No, Your Honor. What the Congress delegated to FDA is the determination whether contraceptives are legal, medically safe, effective, and non-abortifacient.
Okay. I will not prolong the discussion.